Welcome to the end of year course review. Now, in addition to this slide deck, you need to look at the first deck of slides that were produced in the course that talked about compensatory damages and other matters covered at the very beginning. You'll also have to look at the second deck of slides, which covers contempt. Now, this was covered in the first deck of slides, but I wanted to really make sure that everyone got punitive damages. This is where the defendant's conduct includes malice, intentional conduct, outrageous behavior. It's really bad. It's intentional. It's going to scream at you when you see this kind of stuff. The defendant's net worth becomes relevant for evidentiary purposes. And if you go back to the first slide deck, there's 3 considerations that are constitutional in nature that are covered. Make sure you know those 3 constitutional considerations. The net worth becoming relevant is not one of them. And punitive damages generally are not recoverable in contract cases. Now, rescission. Rescission is the unwinding of a contract. The point being that something has gone terribly wrong and both parties have agreed to unwind this contract and return each side to where they were before the contract was entered into. In order to do this, you must give notice of the intent to rescind, return whatever consideration you received, and agree to rescind. Restitution. Restitution is actually easy to spot. You're looking for unjust enrichment. And what unjust enrichment is, will be, did the defendant benefit at the plaintiff's expense? And then once you've hit that, you look at would retention of benefit by the defendant unjustly enrich that defendant? Now, under restitution, there's a few words that'll be used depending on what type of property it is. Replevin would be the return of personal property. Ejectment is the return of real property. Think of an eviction when you think of an ejectment. Most jurisdictions will actually call it an ejectment action instead of an eviction action. The layman will call it an eviction action. It's the same thing. You're ejecting the person occupying that property so you can get it back. And then if it's an issue where you're trying to get the return of profits, you're looking at disgorgement. And if you remember from our examples during the semester, when we had a conversion, and that conversion ended up resulting in large profits for the wrongdoer, usually those profits could be disgorged. Also in wills, trusts, and estates, if a trustee was acting in bad faith or just violating one of the duties they owe as a trustee, there's a possibility that they may have to return profits. Now, one thing to recall or remember is when you're dealing with disgorgement, you may offset the recovery by the overhead and cost attributed to the specific profits unjustly made. The example being the person has 2 different products that they're making at the same facility. One product is the result of this conversion. The other one is something they completely came up with on their own. There's no problems with it as far as we can tell. When you're going to disgorge, you will look at the amount of profits made by that item that was wrongfully taken and produced. And if they can't really do it that way, if there's 2 products in there and they're making about roughly the same amount of items, same profit amount, same of that, that's an easier scenario. You're going to cut it in half, the profit stream, since they're making the same amount each one and the same amount of widgets, we'll say. And then on top of cutting it in half, you're going to reduce it by half of the overhead for the whole factory and then whatever production costs there may be. Now let's talk about interest. And I titled this interest rates just because you'll want to remember that, hey, in certain situations, I'm going to get interest on top of my damages or as part of my damages. We'll look at prejudgment interest first. That's an amount that's owed on something that's certain. The way this moves over into personal injury is that sometimes you will see an offer of judgment or some other kind of state remedy that will be statutory or procedural. And they will allow the defendant to make an offer or the plaintiff to make an offer early in the litigation if it's not accepted by both parties or the party it's offered to. That might become your amount certain, and from then on, they'll accumulate prejudgment interest on whatever the damages ultimately end up being. Post-judgment interest, that's owed on everything after the judgment. Should be really easy. One's before, one's after judgment. Future damages, and this is where I see the confusion on future damages. These are only damages that occur after the judgment, as in the future. That should be easy to get. Keep that straight in your mind. Think of it this way. Post-judgment and future damages are all after the judgment. Now, the future damages are awarded before judgment, obviously, because they're part of the judgment. But they're for things that are going to be paid in the future. And what may happen, depending on the nature of the damages, is they will be reduced to present value. And one thing you want to keep in your mind is that return on investment and prevailing interest rates are important in this matter. A defendant wants a low interest rate and a high rate of return on investment when they're making this calculation. Because if the low interest rate maintains, then with the high rate of return on investment, when they go to reduce to the present value, that amount of damages is going to be reduced much greater than if there was a high interest rate and a low return on investment. So as long as you remember that a defendant wants a low interest rate and a high rate of return, if you just reverse those, you've got what the plaintiff wants. Just remember one of them. So if you saw a question or had to think about it, makes it really easy. Now, injunctions, there's three types. There's TROs, there's preliminary and permanent. The TRO, we'll start with it because that's the very limited emergency motion. You're looking at 10 to 20 days of enjoined conduct. A preliminary injunction is also limited in duration, but it's longer than that 10 to 20, and it allows the parties to maintain the status quo until a permanent injunction case may be made. So if you really want to think about this in the easiest terms, you get your TRO to ensure the status quo remains just for that 10 to 20 days. That gives you enough time to put together your case for the preliminary. And then once you're done with the preliminary, then you're going for your permanent. And the permanent injunction is just meaning that a judgment's entered that orders the injunctive relief. That's all that means by permanent. It doesn't mean it's forever. It just means it's in a judgment. Now, when you look at the TROs and preliminaries, the elements are the same. There's 5 of them. But do this in this order. Make sure you look at ripeness. Remember, con law, constitutional law, is this issue ripe for injunction? Is it immediate? Is the immediacy of the harm, upon us, or is this something that if we didn't do something today, if we waited a month, it'd still be okay? Normally, there'll be a notice and a chance to be heard. That's your due process. However, in a TRO, that may be ex parte, because remember, the TRO is a very emergency type of hearing. That's why it's only limited to 10, 20 days. And in case that there is no notice to the opposing party, it's put into place. And then obviously when you go for the preliminary injunction, notice will be made then and a chance to be heard. And it's fair to the parties that way. I will make it very easy for you. There's 5 elements you need to know for this. 4 of them are the same ones you're going to have to deal with for permanent injunctions. The only one you have to add to do the TRO or preliminary analysis is the likelihood of success on the merits. And this is kind of a predictability test. A lot of times it could go either way. Depends on the court, depends on what facts you're able to accumulate. But that's really the only element that's different. It's this likelihood of success on the merits. So we'll cover the next 4. Now, when we talk about permanent injunctions, look at this. Looks exactly like what you just saw last time. Save, you've lost that likelihood of success on the merits element. So you're looking at ripeness. There's going to be a notice and chance to be heard, and then a 4-part test. You have irreparable injury, meaning that if injunction does not go into place, you'll suffer an injury that you cannot recover from. And we saw throughout the course that this can be kind of a wishy-washy thing. We saw really old trees, 500-year-old trees that were being harvested. You can't replace those. That was irreparable. The inadequacy of money damages. Normally, if you have a adequate relief of money damages, you have a good cause of action at law and not in equity. In this case, you're looking at, will money damages suffice? A lot of times this is an area where you can argue both ways. But if you come out that money damages are not going to suffice, then you've got a good case for an injunction. You balance the hardships of the plaintiff and the defendant, and you look at the public interest. Is an injunction in the interest of the public? Now this leads us to constructive trust versus equitable liens. This can lead to some confusion, but if you remember that normally you can only pick one, you get to select one, you're going to get to do both. This makes it very clear. A constructive trust is good if the asset's appreciating, because when you recover that asset through a constructive trust, you get that whole asset. It's being taken from the wrongfully acquired person, and it's being transferred back to you through constructive trust. This you'll see if there's an unjust enrichment, there's an inadequacy of a legal remedy, meaning that the money damages aren't any good, and you can trace an asset. If for some reason this asset has been sold and you're just trying to recover what it's turned into, you trace the asset that was acquired with the plaintiff's property. So you have to actually be able to trace it to an asset. Equitable lien, the same elements. It's unjust enrichment, legal remedies inadequate, and you can trace it to an improvement or asset of the defendant. Same deal as tracing to an asset. The difference is that with the equitable lien, you're only entitled to however much that lien is worth. So let's say you have a depreciating asset like a car. If you get an equitable lien in place against that car, which is a depreciating asset, you can take that car, foreclose upon it, and sell it. And then whatever is left over as far as what's owed to you, you can get a deficiency judgment for. So remember, depreciating, equitable, appreciating, constructive. And that would be a good way to put it together, because constructive usually means beneficial. Appreciating is what we all kind of want in assets. So take that and hope that helps out. Now, subrogation. Once again, we're looking at the unjust enrichment, the inadequacy of a legal remedy. But here's where it changes. Remember where we were tracing to an asset in the constructive trust or equitable lien? Here, you're tracing to the payment of a debt of another in full. The classic example is someone's wrongfully taken your property, they've sold it, it's turned into cash, they've taken that cash, and they've paid off the mortgage on their house. So, in this situation, since they paid off a debt obligation, you can trace it to that debt obligation. And what happens is you end up standing in place of that mortgage that was paid off, and you get the same, the former creditor's rights, the priority within the discharge realm. So it's pretty good, and security interests. Obviously, if it's a mortgage, there's a security interest. Our example was a house. You have a security interest in that house. So subrogation, remember that's where you're tracing to the payment of the debt of another. Or to think of it another way, you're tracing it to a mortgage. Now, just to make sure we got tracing down, this is where you're going to trace the property. You're going to follow it that was wrongfully taken as it's converted to other types of property. Now, there are some defenses here, like the bona fide purchaser, the BFP. If a house was wrongfully taken from you, and we'll just use house as an example, and someone paid value for it without notice that it was wrongfully taken, then they have an absolute defense for you getting it back from the person. Same example with a car. Someone has converted your car. Someone else buys it. They have to give value, and it's got to be reasonable value. It can't be $1. If it's a $100,000 car and that's the market value, they can't go give in $10,000. It's got to be something in the realm of reason, so that someone's not going to be tipped off to think, hey, I think maybe there's something wrong with this deal. So they're going to have the car. They're going to buy it for value, and they're not going to have notice that whoever has converted this car has stolen it. Now, what happens in real life is there's actually crimes against in the car realm. The accepting of stolen property. Sometimes it's the knowing accepting. So there's other things in there, but just for bona fide purchaser purposes, just remember notice and value. No notice and paid value. Now, payment for value. This is where a creditor of another receives from a third party a benefit in discharge of the debt or lien, and in that case, they're under no duty to make restitution, even if payment is made based on mistake. This is where you've got the three parties, A, B, and C, and A owes money to B, C has wrongfully taken money and used it to pay off B for A. No one can go after B for the money that was paid. Attorney's fees. The American rule, each side pays their own fees. Really easy to follow, easy to remember. The two common exceptions, and there's more exceptions than this, but these are the two common ones you want to keep in your mind. Statutory and contractual exceptions. If there's a statutory provision that awards you attorney's fees, or the possibility thereof, on certain causes of action, then you have to plead it in your pleading and move forward. And once you get a judgment, then you have to make a motion to get paid. Contractual, if it's in the contract that your client has put together, same story. Here's the thing you have to look out for. A lot of times you'll see these contractual attorney's fee provisions that are one-sided, saying if, Acme Brick Company has to sue you to recover, the money that is owed under this contract, or for whatever other reason, we can recover our attorney's fees. It's not going to say anything about the other party. In that scenario, if the other party wins, that attorney's fee provision becomes reciprocal and points right the other way, even though it doesn't say anything about the opposing party. They can get their attorney's fees too. The only time you will see where a attorney's fees provision may actually not flip around is if there's a statutory basis for it, and in that statutory basis, in the legislative history, they make it very clear that this is a one-way attorney's fees provision, and it's because the power of the parties is so unequal. Think insurance company and the insured. Insurance company is a huge deal out there. I mean, they've got licenses and tons of money, and they're making commercials with little green animals and stuff. Where on the other side, you've got Joe Dirt or whoever, and he's just out there trying to make it, in the world, and there's very little power versus a whole lot of power. And in that scenario, you will see legislative intent actually be shown that this is why we've got a one-way deal, and that will be upheld. Now, defenses to remedies. I'm only going to cover some of the main ones that come up. Estoppel. This is where the defendant relied on a statement or act of the plaintiff and changed his position and reliance to his detriment or injury. What happens is the plaintiff will file a lawsuit against the defendant will turn around and either countersuit or raise an affirmative defense of estoppel made on those three elements. And then waiver. This is the intentional relinquishment of a right. What you want to remember with waiver is at that one point in time where they deviate from the contract, that was the intent, that was the intentional act. And you'll see contracts that will say something along the lines of, just because we allow you to pay late on one occasion doesn't mean we're waiving our right to receive timely payment. The problem you run into those with those is that if they continually take late payments, you now have a course of dealing, and you can get around that provision by showing this course of dealing that repeatedly, time and time again, they've taken late payment. Unconscionability. This usually shows up in contracts. It's where the terms are so one-sided or unjust, and the benefit goes to the more powerful party to the extent that it offends the conscience. So when you see that, the unjust or one-sided contract, where next one is the benefits to the powerful party to the extent that the conscience is offended, then you have an unconscionable contract. Laches. This is a defense to cases in equity. It requires substantial and unreasonable delay, the plaintiff's awareness of defendant's conduct, and reliance by defendant to the defendant's prejudice. And usually the way the reliance comes up is the defendant has been proceeding along his own way, had no reason to believe that you were harmed or felt aggrieved. Then you wait a number of years, we'll say 10 just to make it easy, 10 years from the time that the injury occurs. They're definitely going to bring up laches, and they'll have a very good case for that, especially if the plaintiff was aware of the defendant's conduct 10 years previously. And the reliance is that the defendant's been going on operating for 10 years, not even knowing that this plaintiff had been injured, and that the plaintiff's delay was substantial and unreasonable in trying to recover in equity. And then statute of limitations. This is a defense to case at law. Rarely shows up in equity. It's possible a legislature could always do a statute of limitations on an equitable claim. It provides a deadline for filing, but there's two exceptions. There's actually more than two, but there's two big ones that pop up a lot. There's discovery and fraudulent concealment. And the way it comes up is there'll be a personal injury case. The person will not know about their injury until some number of years after the injury occurred. The most common is when someone's been placed under anesthesia, a surgery occurs, something gets left in the body. There's no reason for this person to know that there's something left in there until a few years later. We'll just say 5 to make it easy. 5 years later, they start feeling a pain in their abdomen. They go in to have it looked at. Imaging shows that there's a needle left in their abdomen. It's poking around in there. That's when the discovery occurs. Now, normally they'd have a 2-year statute of limitations in most places under that scenario. That's expired. That would have expired 3 years previous to their discovery. What discovery does is it comes in and protects the plaintiff from the hidden injury that the plaintiff has suffered. Now, just because the injury's been discovered doesn't mean that they've got 2 years from discovery. It's usually going to be somewhere where the outside number is going to be a year. Some really awful cases, they'll extend it a little bit more. It depends on, it's a case-by-case kind of basis, but you definitely want to get that claim filed under a year from the time it's discovered. Be on the safe side. Make your life easy. And then fraudulent concealment, obviously that should be a defense to the statute of limitations defense that's raised. And in that case, you've actually got someone who's intentionally concealed the injury or the fraud to try to avoid liability. And same story there. Once it's discovered, you probably want to act on it sooner rather than later. just like the discovery rule, try to act on it well within a year of discovery. And if you have any further questions, please let me know. You can email me, you can text me. These 3 slide decks cover the vast majority of what's going to end up on the final exam. There may be 1 or 2 other things on there, but if you know this information that we've presented in these 3 slide decks, you should have no problem passing the exam. Good luck.